esteemed guest speaker on the topic of the webinar, that is Introduction to the New Labor Code. Today's webinar is arranged with the objective for introduction and for understanding, deep understanding of the new labor code which are emerging and which will be implemented in the November 2026. So in the changing landscape of employment and industrial relations, labor laws play a crucial role in balancing the rights and responsibilities of the employers and the employees. The introduction of the new labor code that has representing a historic reform which is aimed at simplifying the existing laws and improving compliance and promoting the social security and industrial harmony. This seminar has been organized to create the awareness and deepen our understanding for the important legislative this change, that is a transformation which we are all going to face, and the practical implications on the professional as well as the academic world. And we are really privileged to have with us Advocate Sri Maligaonkar sir, who is a distinguished resource person and whose expertise has in the labor law especially will guide us through the key provisions of the new key provisions and its nuances of the new labor code. I'm very much sure that this session will be highly informative for all of us, sir, and also beneficial for all of us. So on behalf of Dayanand Education Society's Dayanand College of Law, I would like to extend my heartiest welcome once again to our esteemed resource person, Shri Maligaonkar sir. So a warm welcome, sir, and a verbal felicitation from our side, and I express all the respect to you. Sir, before going to the session as such, I would like to give a brief introduction of our resource person. Advocate Shri Dr. Shrikant Maligaonkar sir. He is a specialist in labor laws and industrial relations and practicing advocate at Pune Labor Industrial Court and the Bombay High Court. For past 30 years, he is having extensive experience of 3 decades, more than 3 decades. His consultancy is by the name Maligaonkar and Associates and engages in litigations, consultations, and training in labor laws in India, Indian and multinational companies, along with criminal law, commercial litigation, and subsidiaries. Sir is a graduate in science, law, management, where all the places he stood first class first in the University of Pune. In England, sir has delivered lectures at employment law at the London School of Economics, London, the School of Oriental and African Studies, London, at the University of Maiduguri, Nigeria, and at the People Institute, Israel. So many of the countries sir has delivered the lectures. The academics, the People's Institute, Israel, and besides pursuing the academics at the Berlitz School of Languages, London. Sir has completed the master's degree in law with flying colors and then started his practice at the Bar Council of Maharashtra. Sir is also the recipient of the Settlewide Prize from the Bar Council of Maharashtra. Sir is also an MBA in Human Relations, degree to his credit, and a PhD in Labor Law. Sir is associated with companies like Mercedes, Philips, Bridgestone, General Motors, Amazon, Coca-Cola. So there is a long list where you have been giving your services. Envaliator, Alpha Level, Sweden, Higher Appliances, China, then Credit Suisse, Switzerland, and many more. Coca-Cola, Aerospace, Robbins, Myers, Valmont, USA, Geos Hotstar, India, Envalier, Netherlands, Alpha Level, Sweden, and so many to come. Geostar, India, as well as 5-star hotels, Westin, Novotel, Radisson, and many educational institutions also, like Bharati Vidyapeeth, COAP, Tech University, hospitals like MIT institutions, INLAX, and Budrani. Sir is also associated with 20 banks, NGOs, sugar factories, and many others as their advocate and employment law management consultant. Sir is an ex-visiting faculty in labor law in the ILS Law College, Pune, and also has authored many books and produced TV serials on labor laws. His consultancy, that is Maligaonkar and Associates, imparts training direct and online in labor laws and also has conducted more than 15,000 training workshops for companies like Mercedes, Volkswagen, Telco, Parle-G, Fiat, Finolex, Haier, etc. Sir regularly conducts webinars in employment laws, and his company and is also having a YouTube channel called Simzoo. The link will be shared in our group also, Simzoo. And sir is an ex-president of LLPA, Pune, ex-member of the IR core committees, Maratha Chambers of Commerce, Pune, and sir has traveled over the globe. The YouTube channel is the link will be shared to our groups. So with this extensive experience, expertise, and the lots of contribution to the labor laws, sir, we really appreciate, and you are continue to being the inspiration for and an idol for many of others. So with very heart full of gratitude, I really thank for giving this time for us, and I welcome you, sir. I give this charge to you, and we can start with the lecture, sir.
Thank you, madam.
Thank you very much, sir.
Yeah. Good morning, friends. We will start with right now, and the time which is allotted to me is almost 1 hour, and then we can have 5 or 10 minutes for some of your questions also. First and foremost, a big thank you, madam, for that introduction of mine. You have used more adjectives than I deserve. Anyway, so friends, we start with, I'll just give you a couple of minutes background, and then I will come to my slideshow, and I will share the slideshow with you. Now, what has happened is, as of all of you all understand, in 1947, India became independent, and Pandit Jawaharlal Nehru was the first Prime Minister of independent India. The sky was very murky at that point of time, and there were no laws which would control the Indian industry, and that is why different laws were enacted. Say, for example, 1947 we had the Industrial Disputes Act, 48 we had the Factories Act, 52 we had the Provident Fund Act, minimum wages again 1948. Likewise, there were a deluge of laws. And coming till say 1965, we had the Bonus Act. 1970, we had the Contract Labor Regulation and Abolition Act. 1971, in state of Maharashtra, we have the Maharashtra Recognition of Trade Unions and Prevention of Unfair Labor Practices Act, so on and so forth. Now, what has happened is, sitting in some corner, sitting in your canteen, sitting in the canteens of industries, factories, seminars, somewhere, I mean, people have contributed to labor law. And over a cup of tea with our friends, we have expressed whatever is going on is not right. And then somebody says this would be the solution. Same happens with all other topics also. Somebody says there's too much of corruption in India, and in his or her own way, people suggest methods that this is the way, according to me, corruption can be curbed. This is the way, according to me, population can be controlled. So we all contribute in our humble ways to whatever are the problems we see in India in our closed quarters or between friends also. Seminars, law commissions, everywhere these topics were discussed. Added to that was Supreme Court judgments. Because law ultimately is crude law. It's just the bare act. And then we had big judgments, landmark judgments in all branches of law as well as labor law. Now, taking lessons from all of this, the present government thought it right that time has come for India to change the total setup. And in my opinion, friends, this is the major overhaul which has taken place right from 1947 till today. This is the biggest change. 29 laws have been repealed. And the government wants to have an India which is eyeing on a $5 trillion and a $7 trillion economy. We all want to be rich. Is there any person in this class, including myself, who does not want to be rich? Or is there any country who does not want to be rich? That, okay, we are at a certain level, and then tomorrow we want to be poor, and ultimately we go down the poverty line. Is there anybody? No. We all want to be rich. We all want dams. We all want roads. We all want all infrastructures, all good things on earth. Everybody requires. And moreover, what has happened is India is facing competition because ultimately the world has become a global village. Our competition is with the Western countries as well as, say, the Asian tigers like Taiwan, Singapore, Japan, China. all of them. And those people are not bothered as to what labor laws you are having in India. Now I represent so many multinationals. Madam read a few of them, right, from Mercedes or whatever. These people come to India. Why? Because labor is cheap. And moreover, they want to make profits. If you have ever heard, Maruti Suzuki, when it came for the first time in India, there was no middle class car. All middle class people wanted a car. So a small car was necessary. Ultimately, Maruti Suzuki launched. And somewhere I should tell you, in the year 2000, when the market was still open, we had other brands also, say like Santro. And when other brands started entering, what do you know what Maruti Suzuki did? It reduced the price by 25,000. The Maruti car costed 2 lakhs of rupees. And out of 2 lakhs, they reduced it by 25,000. So the question is, this 25,000 rupees was Indian money which went into Japanese pockets. And they are not bothered. Any of the foreign countries are not bothered what labor laws you are having. It is you and your country. Whether you terminate people or dismiss people or deal with unions or don't deal with unions. What do they lose? And this was sensed by the present Modi government also. And ultimately, there were calls from so many quarters that we have to change the setup. And if India really wants to go for a $7 trillion economy, and India wants to be a developed nation in 2047, you cannot do it with the present set of labor laws. So at the grassroots level only, you have to start changing. And with this much of a background, friends, I will now start sharing my PPT. Time is limited, so you will a bit excuse me if I am a bit fast. So just let me share it with you. Just 1 second. Just a second. I'm already sharing it. Just somebody just tell me whether you can see the PPT.
Sir.
Can you see it?
PPT is visible over here, only on the presentation mode. Yeah.
Okay. Everybody can see the slide now? Hello?
No, sir, you are visible now. Slide again if you share. Previously it was shared, sir. Once again, if you share, it will be.
Yeah. Yeah. Just see. Can you see it now?
No, sir. Now it is 1 minute.
I'll start the slideshow. Just tell me, madam, whether the students can see it. The slideshow. Can everybody see?
No, sir.
Okay. Now can you see?
Just a minute if it is visible.
I'm sharing the PPT.
Not yet.
Earlier it was seen. Okay. Can you see this?
Huh.
Okay. I'll not disturb this, even though, this is not the slideshow, but people can concentrate on the slide.
Yeah, yes. Yes,
so that
yes,
there
sir.
should be no technical glitch. Okay. Friends, we start.
Mhm.
Now you see, today we are having a new
Sir,
era of Indian
Sorry,
labor.
sir, the slide is not visible. If you can share the slide, sir. Yeah.
I'm already sharing it. That's what.
So I think the sharing of window is required, or the.
Yeah, just 1 second.
Yes, sir. Yes.
See, I press the share button.
I think it might be asking sharing the screen.
Just 1 second. I'll just check it again.
Yes, sir. Yes, sir. Please take your time. No problem.
Can it be seen now? Madam?
Yes, I think it is coming. It's now we can see your screen with the.
Yeah. So shall I continue?
Yes, sir. Yes, sir.
Yeah. Now, my friends, we usher into a new era of Indian labor laws, and today we are having four codes from the fragmented labor laws, and ultimately we see a unified governance. Now, India, they say, or rather, it's a criticism that we have too many laws and too little justice. And basically, when I was in your class, I remember having abused the framers of the law, as well as the board of studies and the university and whoever I could see in front of me, because I had to study a lot. What is the definition of an employer in Provident Fund, and what is the definition of an employer in this act, and what is the definition in that act? So many laws to remember. And why? What is the necessity? Why can't you have a composite or a unified definition itself? Is what I thought with myself. And today is the day when these things have come up. Okay. Can you see the next slide now? Hello?
Yes, sir. Now it is
Yeah.
seen.
So, okay, we'll keep this set up so there is no technical glitch and we don't waste time in
Yes,
that.
sir. Yes.
Now, you
Yes.
see, why are we talking about labor codes today? Why this reform matters now? Now, India's economy has evolved right from services, platforms, gig work. If you compare Indian economy, when I was in school, I was told that India is an agricultural country. Poems have been written. Bharat ka vaibhav hai kisan, Shramjeevi Manav hai kisan, and whatnot poems I have read when I was in school. And 80% of the Indians are engaged in agriculture. But the point is there a necessity of so many Indians into agriculture? If you compare the economy of India and Hong Kong, in Hong Kong, there is a total service sector. They sell services. He is a dentist, he is an architect, he is a chartered accountant, he is a lawyer. So likewise, they sell services. And Singapore and Hong Kong, they are much more doing better than India. So Indian economy today is slowly evolving. With lesser people in agriculture, you can still do good, and the remainder of the people can be in something else. And that is why we are today having services. We are today having platforms. Say, how does Uber function or how does Ola function? They function on a platform. And what about Swiggy? And what about your Blinkit? And what about those porters? They are all gig workers, which were not present in the definition section 2S of the Industrial Disputes Act even today. Now, old laws were fragmented, complex, costly to comply with, and the businesses needed clarity and the workers needed wider protection. In India, we understood only one thing. Remember, when I was in college, there were only three branches we had: art, science, and commerce, and that is the end of the story. Madam introduced me, I am a science graduate, yes, because there was no other option available with me. Today, there are so many options with students. Right after 12th, you can come into a law college also. These things were missing at that point of time. Likewise, workers also, I mean, they need protection. We only have one thing, that you join some service at the age of 18 and retire at the age of 60. And after 240 days, after in accordance with the Industrial Employment Standing Orders Act, you become permanent. That is what our workers understood. Now, this has led to many headaches into India. Now you see digital governance, uniformity, provide predictability. Codes are these codes wherein 29 laws are repealed and the rest of the laws are into four codes. So today we have only four codes, which is the topic of my discussion. Now these are implemented, friends. Let me clear certain things right now only. The implementation has taken place from 21st of November. However, as you understand, being law students, labor is a concurrent subject. So we have central labor laws as well as state labor laws, but then the rules are yet to come. In a way, I would congratulate your college for being timely in introduction of this sort of a lecture, because the rules are knocking on the doors. According to the central labor minister, the central labor rules would be in place on 1st of April. And then with all whatever has happened with in state of Maharashtra, the state rules are yet in the making. Then we had the Bombay elections and then the corporation elections and now the Zilla Parishad and Gram Panchayat and the sad demise of Ajit Dada Pawar and all of that. It's taken a bit of time, but then what I foresee is by say 1st of May or 1st of June, we would be having whatever are the rules. And once the rules are there, then there will be a total implementation. What we are going to see is how it would be. Now, the problem with old labor laws is we had a fragmented maze, overlapping rules, multiple authorities, inconsistent definition, different meanings of wages and worker. I remember there's a judgment of Justice Sirpurkar, wherein who is a worker and who is a protected worker under the Mathadi Act is defined. Then we had so many judgments. It's just into we engage into academics and discussions and arguments after arguments. Question is, if India wants to be rich, it can only be by industrial production. It cannot be done by I doing the talking and you doing the listening. Ultimately, it's industrial production. How many, I mean, India is now multiplied its arms and ammunition also. We sell it to other countries. Why? Because that brings a huge profit. Once profit comes, we all become prosperous. So all these things have to be done away with. High compliance cost, time, money, litigation, outdated coverage. And you see, today we are having gig workers, platform workers, informal workers were and unorganized workers to an extent were excluded from the definition of Section 2S of the Industrial Disputes Act, which defined who is a workman. And today we only know a workman is a person who does manual, skilled, unskilled, technical, clerical, and operational work. And that's it. We only knew this thing. Going further, friends, so a big reform movement was necessary, and we have all contributed. You have also knowingly, unknowingly contributed. Discussing how should labor laws in India be over a cup of tea is also a contribution. And all of these put together, ultimately, we come down to 2020, wherein the government thought it wise to have 4 labor codes and simplify everything. We still go further. Now, what do the codes achieve? First is simplification. I remember what Albert Einstein said, which I remember it when I argue cases in courts, which all law students should be knowing this. Albert Einstein said that if you cannot simplify a thing and explain it to your friend, you have not understood it yourself. Any complex theory, if you have to make it so easy that your friend, possibly who is 10th class fail, should understand it. That should be your ability. This is what exactly. We are into a maze. Nothing was clear and more interpretations and more interpretations. Do you know one thing? There are at least more than 7,000 judgments only on one word, that is who is a workman. Then you have to digitize online portals, digital inspections, transparency. Now you see, on the one hand, you are having a digital economy and so much of digitalization is taking place. Why it cannot affect, or it has to creep over your labor laws also. Then standardize, uniform definitions of wage, employee, establishment. In that act, it is something different. In Bombay Industrial Relations Act, it is different. In Industrial Disputes Act, it is different. If you read the law, Bombay Industrial Relations Act or Maharashtra Industrial Relations Act 1946, Section 313 is pari materia with Section 2S of the Industrial Disputes Act. But why do you have to have so many different definitions? Then you have to, then the protection, wider social security, inclusion of gig and platform workers. Do you know one thing? Some days back in big cities like Pune and Bombay, these gig workers, the Swiggy boys and the Blinkit boys, and all of them, they went on a strike because all these platforms have advertised one thing, that you want a pizza, place an order, and in 10 minutes we will deliver the pizza at your house. Who does it? It's these delivery boys. And what are the laws which govern them? There is no law which governs them even today. Rules are yet to come. So there are no laws governing even today, which they have been taken care of in the labor codes. The foundations of Indian labor law. This I will be a bit quick because we have to touch upon other things. The foundations of Indian labor law are welfare driven from the beginning. If you see, slowly and slowly, I mean, everybody has contributed. Forget everybody, but then the big stalwart leaders, outsiders you can call. The first outsider into a trade union was Mahatma Gandhi himself. Then we had people like Sripad Amrut Dange and N.M. Joshi and Manvedranath Roy and George Fernandez and so on and so forth. But they all have contributed. Now, from protection to proliferation, when laws multiplied, by the late 20th century, we had 40 central labor laws. and over 100 state labor laws. I just now told you, too many laws and too little justice, too many controls and too little welfare. This is what was India. I remember one more thing, friends. While I am talking, I am not holding the brief for any political party. Congress has also contributed to India in certain ways, and the present government is also contributing. So that's not the point. That's something that when you start talking on labor code, you go on criticizing the earlier. No, they have also created a background. And that is why, as Madam, while introducing me, rightly used a word that we are having the present and the old ones, they work in tandem or they are going to work in harmony apart from the repeal which has taken place. Okay. Now, when the economy has changed in 1991, you see economic liberalization started. And then the key challenges were rigid retrenchment and closure norms. Today, even today, I mean, you cannot close down an industry so easily, especially when there are more than 100 workers. And as students of labor law, you are aware that after 100 workers to a factory, plantation, and mine, Chapter 5B of the Industrial Disputes Act becomes applicable. You must have heard of a company called General Motors. General Motors, they manufacture some cars, Sail, Cruise, then your Spark, and then they have faced a closure. Malegaonkar and Associates, we were instrumental in closing down that concern. And I remember having argued the matter before the Honorable Labour Minister, Mr. Y.S. Patil, and we said 10,500 crores is the loss, not the cost of the company. That is the loss. And then there were huge arguments and this and that. But what I'm trying to emphasize upon you is, does the government allow a closure after 100 workers? Answer is a simple no. Does the government allow retrenchment? Answer is a simple no. That is today's law, and that is why there was a necessity of some change into it, which is brought about by the labor code. So workers are going to experience now more informalization. Contractual employment was there, but without social security. All contract labor employees, that is under the Contract Labor Regulation and Abolition Act, he is on my role and he is on the contractor's role. And they were given a stepmotherly treatment. So in one of the poems or something, I remember Gulzar, the poet or the Gitkar in so many films, is written, एक इस भारत में दो भारत बसते हैं. So there are two Indias in one India only. So one are on the principal employer's role and one are on the contractor's role. Both stay in same India. Both are citizens of India. But the permanent people on the employer's role get something different. Contractor's roles, something different. Here you require a departmental inquiry to terminate anybody. There for the contractor, what you do? How do you remove people? Very simple. Take a phone call. I mean, just pick up your mobile and give a call to the contractor and tell him, from tomorrow, ye aadmi mujhe dikhna nahi chahiye. That is all. And the contractor labor goes home. And as far as employees who are on your role, that is on the principal employer's role, you have to hold a departmental inquiry in consonance with the principles of natural justice and give him a charge sheet and this and that. So why should there be two sets of employees? And this is going on for ages in India. Okay. So rethinking of labor governance was very important. And the move was towards the code simplification, removal of definitional inconsistencies, technology-driven compliance. Now you see, an inspector comes to your door place and he says, come on, show me your register. First and foremost, Modi government is very clear. Why should there be a register only? Why cannot you keep an electronic document? And why should the inspector go and inspect your premises? Can't the software do it? India, friends, you are aware that India is having the largest scientific force in the world. So what are these people doing? Instead of you going there personally and checking everything, put up a software and the software is going to do it. And that is what exactly is going to happen. And balance flexibility of all employees. Now, from old law to the new code, what has actually changed? The introduced, we have substantiative changes that directly alter wage computation. Now, friends, wage computation, I'll just in a few slides explain you how. Hiring termination, union formation and bargaining has changed today. Social security eligibility has changed and safety obligations have also changed. Now, all this led to the birth of 4 labor codes, and the codes are code on wages. So everything related to wages in one code. Industrial relations code, that would include Industrial Employment Standing Orders Act, industrial disputes, trade unions. So they all deal with the relations with the union. So that is in one code, that is Industrial Relations Code. Then there is a code of social security. What about my gratuity? What about my provident fund? What about my ESI? And then there is occupational health and safety, which we will see very quickly. Now, why consolidate labor codes into 4 codes? To remove the complexity, remove overlaps, contradictions, and all of those things, and may ultimately have a balance worker welfare with business. Now, code on wages we start with. Now, code on wages 2019 creates a uniform legal work for wage regulation across all sectors and employments. It consolidates Payment of Wages Act, Minimum Wages Act, Bonus Act, and Equal Remuneration Act. Now, you understood that in Payment of Wages Act 1936, you had those permissible deductions. Minimum Wages Act means under Edward Mills case, Supreme Court said, if you cannot pay the minimum wages, you have got no right to exist itself. Payment of Bonus Act, 8.33% is the minimum bonus, 20% is the maximum bonus. Equal Remuneration Act, males and females cannot be paid differently. So here, standardized, number one, they say, definition of wages, ensure universal minimum wage coverage and promote equal remuneration. Now, I'll tell you one more thing. What has happened is government is going to introduce a floor wage. There was a company called Racold. You must have heard of it. They produce geysers. And then some wrong industrial relations were there. Ultimately, they landed up in paying every employee, that is the worker, 45,000 rupees per month. These were the wages. Thereafter, I became their lawyer, and then we had a marathon meeting at Hyatt Hotel in Pune, and in which all those Italians, they had come all the way from Italy. And ultimately, in those days, what happened is Modi government came into picture and they granted a huge subsidy to all of these geyser companies who went to Panchkula in Himachal Pradesh or they went to Northeast. Now, Northeast is Meghalaya, right from below Assam, Meghalaya, Nagaland, Manipur. If you compare the minimum wages there and in Pune, it's a world of a difference. In Pune, approximately it is 15 to 17,000 minimum wages. There you get a person to work in 7 to 8,000. So half the price. Plus subsidies were given. So the geysers, other companies started selling it very cheap, which Racold could not because they are already paying their workers 45,000 rupees. And once you pay a worker, you cannot decrease the amount. So with all of this, slowly and slowly, what is the effect? Effect is very simple. Racold company was closed down. And what about the workers? Hello? Racold company was closed down, and ultimately what happened? All the workers were on the streets. This will be taken care of now. Code on wages. See, minimum wages applied only to scheduled employments. Wage ceilings were there. Employers structured salaries to minimize provident fund and gratuity. Under the new code, what is going to happen is minimum wages apply to all employments. Then national floor wage is introduced, whether you work in Manipur, whether you work in Pune, or whether you work in Panchkula, or whether you work in Kanyakumari. Below a certain level, your wages cannot drop. Uniform definition of wages. And this is the most important thing. 50% of remuneration will be treated as wages. Now, earlier, what used to happen, let me explain you this. A salary is equal to basic salary plus dearness allowance, which in the vernacular is called as Magai Bhatta. Then there is a house rent allowance, and then there are other allowances. Now, of these two components, that is a basic wage and dearness allowance, basic and DA, a combination is equal to minimum wages. So what people in India started doing, Indians, Indians are, we have an Indian brain called as an Indian Jugaad. So they said 10% basic and 10% will be the DA. Rest is all other allowances. Now the trick is here. The moment you reduce the basic and the moment you reduce the DA, what happens is your provident fund is affected. because your provident fund, your bonus, your ESI and your gratuity all is based on basic and DA. So if you decrease basic and DA, you do not have to pay that much of gratuity. Provident fund also becomes less. So there is money saving for the employer. But then at the cost of what? At the cost of social security. I remember there was during lockdown time, there's a hotel in Pune called O Hotel. And a woman came to my office and she said, my husband expired in in COVID. And then when I saw her salary sheet, I got a shock of my life. 10% basic and 10% DA. So even after working for 20 long years, her husband was to get peanuts as far as gratuity is concerned. And I remember having sent a notice to O Hotel wherein I said that I'm going to take you to task now, because this cannot be the social security. Now, friends, this has been cured in the labor codes itself. All accounting systems all over India will have to be changed now, because according to the government, basic and DA will essentially be 50%. You cannot drop 1 rupee less than that. And so that 50% will be the basic DA, and then the remainder will be other allowances, which includes the house rent allowance also. Gender neutrality expanded to include transgender person. So gender neutrality, there is somebody's mic which is, I'll request you to, I could
Hello,
hear.
please, the participants are requested to mute their mic. Please pay attention to your mic. Otherwise, you will be removed from the meeting.
So gender neutrality expanded to include transgender persons also. Transgender, LGBT and all of those things you are better aware of. So they are now included in this. Now you see the 10 major changes brought under the Code of Wages are uniform definition of wages. And then the wages will be, for the first time, single comprehensive definition of wages has been provided, limiting allowances and excluding certain components beyond the prescribed percentage of 50%. In other words, friends, basic and DA essentially will be 50% because your provident fund is based on that, gratuity is based on that, bonus is based on basic and DA, and ESI. ESI is of course on gross, but which includes basic and DA. Then the merger of 4 labor laws. Then you have universal application of minimum wages. Minimum wages now apply to all employees across all sectors. Earlier, it was only to scheduled employments. And then what about the rest? And lastly, you have the statutory floor wage, which government is going to declare that it's like minimum wages. But this all over India, what happened? Maybe in COVID, you must be knowing migrant workers. Why do people come from Bihar to state of Maharashtra? Because here the wages are more. So they said we should have a national floor wage. So India should have a balanced economy, in the sense you go anywhere in India, this much is the minimum, you will get it. More they don't explain, but minimum this is anywhere. So these migrant labor, they had posed so many problems. You must have seen it on television. People marching from Bombay back to Bihar, not even by railway, they went on foot. So all these problems should not arise in future. Then timely payment of wages mandated. So when do you pay them? Today, under the Payment of Wages Act, before 7th of every month, you have to pay the wages. So you have to make timely payment. And one more thing, let me tell you, as we are passing through, the penalties, friends, for non-compliance are twofold. First time you make a mistake, say for example, this is just an example. First time you make a mistake, you will be fined 5,000 rupees. Second time you make a mistake, you will not be fined 5,000 or 7,000. It will directly be 50,000. That will be the difference. So the first time, whatever you do, you make mistakes, you don't follow the law, government is going to be lenient with you, but not the second time. Okay. Gender neutral equal remuneration, simplified bonus eligibility. If you read the bonus act, it is too complicated. What is allocable surplus? What is available surplus? What is carry forward? And what was the, if so many. Now you say you simplify. Bonus provisions are retained with clarity on eligibility, calculation, and disqualification. So then single inspector come facilitator. First and foremost, that inspector's name itself is changed. He is now not an inspector, he is a facilitator. As the Prime Minister, Honorable Narendra Modi said, I am not a Pradhan Mantri. I am a Pradhan Sevak. So they say that all government employees are sevaks. So we are here to serve you. And so he is not an inspector. He is a facilitator. So he is going to help you as to how things are to be done. And this could be web-based inspections, reduced discretionary powers, then enhanced penalty. This, of course, let me be very frank with you and let me pull no punches in telling you and be very blunt and frank. This is going to reduce a bit of corruption also in India. Enhanced penalties and compounding of offences, higher penalties for non-compliance along with provisions for compounding of certain offences, encouraging quicker resolution. And finally is digitalization and ease of compliance. But there is some bad news. See what happens is, friends, let me be very frank with you. Suppose if I travel on a bicycle and then there is nobody at the signal. So whether the signal turns green or red and blue and yellow and whatever, it hardly bothers me because I'm not going to look at that. And this I'm doing it say for 10 years. And one day I find that there is a Havaldar now who is standing at the signal. And then the moment I break the signal, and then the moment I travel when there is a red light, he is going to stop me and challan me. Now this creates irritance with me, annoyance with me, anger with me, and this is exactly what has happened with all Indians. We are all conditioned to live in a certain manner. That kuch bhi chalta hai. And yes, let that inspector come. I will manage him. Manage here is taken in a very different form. All this, the moment you introduce some change, with every change, there is going to be some resistance and annoyance. You see, government cannot, any Raja cannot live or his kingdom cannot live without taxation. That lagan has to be there. And then the moment something is taxed, there is a furor all over that such a taxation, what are they doing? So much of taxes and this and that. But then how are you to see? We all want a good road and good dams and everything, but where is the money? And if you are not going to have proper facilitators and if you are not going to have proper implementation of laws, India slowly and slowly will be going to the in the waste paper basket, which certainly is not in tune with the idea of a welfare state which is enshrined in the Constitution of India. So we have to take care of all of this, which they have. Then the next industrial relations code, managing workforce relations, etc. So it consolidates, as I told you, Trade Unions Act 1926, Industrial Employment Standing Orders Act, and ultimately the backbone of the Indian industry, that is the Industrial Disputes Act. Now, this is the regulation and recognition of trade unions, formalization of standing orders, and streamlining dispute resolution mechanisms. Now, you see, these dispute resolution mechanisms, I myself, I am a lawyer. Basically, why do you require so many disputes and every Tom, Dick, and Harry getting up and going to the court? Do you know there are so many cases in cold storage? They are into crores. Then government started Lok Adalat. It is not delivering the goods to its fullest extent. Then you say mediation is started. And nothing, even then, population of India has also increased. 152 crores of Indians, and everybody is educated in comparison with 1947. So all these educated laws go and file cases. And once they file cases, it creates a burden and a pressure on the judiciary. And then you go by CPC and this and that, and it's a dilatory procedure, which is not the topic of my discussion. But this certainly has been taken care of in the Industrial Relations Code. Now, major substantiative changes are what? Retrenchment. Here, this is a big eyesore for the unions. Today, what happens is standing orders in India, or say Chapter 5A in India applies to a factory, plantation, and mine, wherein more than less than 100 workers are there. More than 100 workers, Chapter 5B. Less than 100 workers, Chapter 5A. So if you have to retrench people, if you have to close the unit, you have to take a government permission if you are employing more than 100 workmen. This is what it means in simple words. Now this 100 figure is extended to 300. So the unions are saying till 300 it is an employer's paradise. You can remove people. You just have to follow something. If he's committed a misconduct, then you follow the departmental inquiry, hold an inquiry, terminate him. Now, what the unions are saying is, how many industries in India employ more than 300 people or 300 workmen? Hardly 15%. So it's an employer's paradise for 85%. This is one part of the story. But then, in my 30 years of practice, I have also seen private industrialists who employ 50 people or who employ, say, 70 workers. And then there is a union, and then there is a big deal of a dadagiri and an extortion. And then ultimately units are closed. So you see whether who loses and who wins, whether the union or the employer is not the point. Ultimately, who loses is you and me, because national wealth is being wasted in all these things, and that is why Modi government said that we will take up the figure to 300. And in between, that is from 0 to 300 workers, how would there will be no standing orders also. I told you 29 laws are repealed, so standing orders act are also repealed. For those students who don't know as to what is standing orders, I'll simplify it. What is standing order? Making it very, very simple. See, you and me both were in school. So there was a roll number, there was some division, we both had. Some rules were applicable. Then we came in college, you are still in college. You are having a roll number, you are having a division, whatever. Some rules are there. Is there a college where no rules only are applicable? No, rules are applicable. So likewise, after this, when people go in industries, some rules will be applicable. So when a policeman is standing, some rules are applicable to him also. That is Maharashtra Civil Service rules. College professors are there. The university statutes are applicable to them. School teachers are there. Maharashtra Employees of Private Schools Conditions of Service Act 1977. That is applicable to them. For industrial workers, standing orders. In simple words, standing orders are rules. These rules were applicable in state of Maharashtra or are even today applicable after 50. And this figure of 100 for plantation factories and mines, where chapter 5B applies after 100, that is now extended to 300. This is what has exactly happened. Now fixed term employment is allowed. Today fixed term employment under the model standing orders, that is the model rules, it is not allowed in state of Maharashtra. So the labor codes allow. I am an employer, because you see friends, contract labor, I am saying it is all abolished now. There is no contract labor, it is repealed. So after the rules of the labor code, we will be having no contract labor. Then what? I am an employer. Manpower planning is a management function. So what I do? How many people I'm going to require for 2 years? I say 50. So I will appoint 50 people for 2 years. And in the appointment letter only, I will tell them you are appointed for 2 years only. After 2 years, we both are going to bid a goodbye to each other. Today, what happens in India? You employ a person, he joins after 240 days, that is 8 months, in 8 months, 30 days per month. So in 8 months, he completes 240 days, then he becomes permanent. And then you understand that this permanent person, so 18 years and 8 months, he becomes permanent. And on his 19th birthday, you understand he is a good for nothing fellow. He knows nothing. But you have to drag this good for nothing person till he retires at the age of 60 as per the model standing orders. I hope you all are getting me. So India cannot progress with all these lame talents. And how many people? Everybody, permanency is a very, very big phenomenon in India. I remember, just to tell you an example, some months back, I went to my village. And a village elder man, his daughter was getting married, so he was distributing wedding cards. Listen carefully. So when I went there, he gave me a wedding card and said, "Come for the wedding." I said, "Okay, okay." When I opened the wedding card, it was like a usual wedding card. The name of the, uh, his daughter, the bride, her name was there, daughter of so and so. Then is the bridegroom, that is the would-be husband. His name is there, son of so and so, which is a usual wedding card. Below that, below the name of that would be husband bridegroom, it was written permanent in service. So when I saw that, I raised my eyebrows, looked at him, that he is written permanent in service in a wedding card. But then it's one of my habits. I enter into the other person's shoes. So I entered into his shoes and he appeared more right to me. That his daughter is getting married and she's got a husband who does not only have a job, but is permanent also. So he is more justified in writing that is what I understood. Because permanency is a prized possession in India. That is the value of permanency. Do you know what has happened with the labor codes? Permanency is removed now. I want you for 3 years. So 3 years I will appoint you fixed term employment, but for 3 years you have to pay gratuity also. Today gratuity is payable under the Payment of Gratuity Act 1972 after 5 years only. In this scenario, per year you have to pay gratuity. I'll give you an example. Say I am an employee, I work in A company for 4 years, B in for 4 years, C for 4 years, and D for 4 years. So 16 years I have put in. How much gratuity I get is a big zero, because nowhere I have completed 5 years. In this situation, even if I complete 1 year in one company, I will be getting gratuity if I am a fixed term employee. Then I told you strike definition to include mass casual leave. You must have seen this. These banks, pen down strike. There are so many types of strike. General strike, pen down strike, sit down strike, go slow strike, hunger strike, quickie strike, lightning strike, ghera, so many of them. But one much which was very much in vogue and fashionable is Lekhni Band Andolan. Means I keep the pen down and everybody goes on mass casual leave. En mass casual leave is a form of strike. Supreme Court, I'm sorry, the Labor Code say that henceforth en mass casual leave will be a strike. Earlier it was missing in the definition of strike. Strike, as you understand, friends, under Industrial Disputes Act is defined in Section 2Q of the Industrial Disputes Act, that strike is a total cessation of work by a body of persons acting in combination or a concerted refusal under a common understanding. And one more thing, what they have done by the labor codes is a mandatory notice for strike in all establishments. You have to give this much of a, so that we can make alternate. So this gives a operational flexibility for employers. Now 10 major changes brought under the labor code are higher threshold for standing orders. I told you today the earlier threshold is 100, today it is 300. Prior government permission for retrenchment, layoff and closure. Now permission is required only after 300 workers. Till 300 no permissions are required. Because friends, from 15th of August 1947 when India became independent till today, not one Tom, Dick and Harry has ever got a permission. Government does not give a permission to close down. So what they do, answer is very simple. I remember having interviewed a big industrialist, names are not important, on the radio. He said, we don't pay the electricity bill only. So the MSCB people come and cut the electricity. And then I tell the workers, there's no electricity, how can I produce? In slow, then I stop paying the vendors, so they don't supply. Slowly and slowly the industry dies its death itself. And what happens to the workers? They are all again on the streets. So government never gave a permission in 75 years since independence. This is cured here. Fixed term employment statutorily recognized. Today, as I told you, under model standing orders, fixed term employment is not allowed, which it will be allowed in the uh, industrial relations. Sole negotiating union. Now today you see Maharashtra Recognition of Trade Unions and Prevention of Unfair Labor Practices Act 1971. It's a state act. A purely special recognition of unions under this act. So, and so many cases and so many disputes, inter-disputes, intra-union disputes, and what is, I mean, why we are wasting national time and man hours? So now the employer will say how many members are there, more than 51% employer will grant him recognition. Today recognition is to be granted by the industrial court, which is taking donkey's years in courts again. And again, a load on the court and pressurizing the courts for the same. This will be made it very simple. Employer will say, if at all, sir, the unions do not have 51% membership, then you look at other unions and members from all other unions representatives and make a negotiating council. That is what. Then what they have done, work expansion of worker. Wage ceiling is to 18,000 rupees. Still 18,000 rupees would be a worker. However, this is an outmoded test because the nature of duty really defines as to who is a workman. Mandatory notice of strike and lot out. 14 days notice was mandatory. Notice remains valid for 60 days and applies to all establishments, not just to public utility. Now this curtails sudden strikes. I told you, Japan, Taiwan, Singapore, China, America, USA, your Germany, UK, whatever. They are hardly bothered how you function in your country. And then a lightning strike. And then immediately everything comes to a standstill. Now, no, production should go on because India can only be rich by production. Let us understand this by simple common sense that if there is production, it will go on. Just I'll give you a simple analogy, very simple to understand. Husband and a wife in a house have a fight, and the husband says that I am not going to work only. He does not go to work, so his employer does not pay him. So the family starts suffering. There is no food to eat. Wife also starts suffering. Children also start suffering. Why? Because he's taken a decision not to go to work. This is exactly what has happened here. If you want to go on a strike, then you have to give this notice. Then increased penalties and compounding of offenses. Okay. Then time-bound dispute resolution. Earlier, conciliation, there was no time limit only. After 20 years, people are filing cases for conciliation and they are also entertaining it. Then came a few judgments here and there that no, it should be within some time limit. But now this has been taken care of in the this has been taken care of by the courts only. After there is a dispute, one more thing, there is a grievance redressal committee which has to be established everywhere. So you have a dispute. Today what people do, you have a dispute, you go directly to the court. Again, this increases court pressure. Now what people will be doing, you take their grievance before the grievance committee. If that is not done, then you take it for conciliation and the time limit is 45 days only. Thereafter, it will be referred to the court. Means which court? That will be only an industrial tribunal because labor courts are abolished now under the labor codes. No labor court henceforth. So industrial tribunal will be 2 members. Today there is only 1 member. So 2 members will be, one will be a judicial member and one will be an administrative member. And after that, the case, the trial will go on. After that, High Court and then the Supreme Court. That is all. Then time bound, I told you, reskilling fund for retrenched workers. Today, retrenchment is under Section 25F of the Industrial Disputes Act, a compensation of 15 days average pay per completed year of service. Now, here what will happen is you have to give 15 days more payment to the worker. But that payment is not to be given to the worker. You have to deposit it with the appropriate government. And that is called as a reskilling fund to allow the person to find another job. And the simplification of all other labor laws. Okay, so these are some of the changes we see. Time is limited, slides are many. Okay, so and you see ultimately the safety net, employees compensation, state insurance, provident fund, this is also changed, maternity benefit, all of these benefits, that this comes under social security code which have to be given. Newly recognized categories of workers are gig workers, platform workers, unorganized workers are also given something. And then the changes are gratuity is after 1 year, aggregators contribute 1 to 2% of turnover, accidents during commute. I am coming to the factory and I meet with an accident. Earlier things, Supreme Court had to bring in a doctrine of notional extension. Now this is included here only. Even if while I am going to the factory, I meet with an accident, compensation becomes payable. Okay, so and then the major changes introduced are consolidated of social security law, universalization of social security coverage, recognition of platform workers, expansion of definition, then mandatory registration of worker establishment, and portability of social security benefits. So these are new things which have started. It's already 10:16 and it's almost 1 hour I am talking with you, but time is limited and I also have to answer questions from you, if any, and it would be a delight of mine to answer your questions. But this is in some way in the least possible time. We try to understand, we in the sense you and me both, as to what are the labor codes. So this is in simple words, what were the labor codes, of course. It should not convey you a message that it is only this much. There's much more to it, but then time and all of those things are very essential for this. So what we do is that I'll revert back to the portal now, and then you can ask me questions also. And you have been a great audience and given me a patient hearing. Okay, so thank you for that. Yeah. Can you see me?
Yes, sir.
Yeah.
It is visible.
Yeah.
Thank you very much, sir.
Yeah.
I would like to ask the audience if there is any question relating to the present topic. You can just raise your hand. Yes, Mr. Patil, sir, please. You
Madam,
can
am I audible?
unmute. Yes, yes.
Sir, my question is very simple. Do you think we took very long to introduce changes in new labor codes? This is my first just minute, and this is my first question. And the second question: those people who are criticizing these new codes are saying these are not the labor reforms; these are industrial reforms. So I have these two questions. Can you please tell me?
First and foremost, just to answer your first question, have we been late? Answer is yes, in my personal opinion. Now you see, people who criticize, I mean, today is a time, almost every third day I'm giving a lecture on labor codes here and there. In Pune, there is a newspaper called Sakal. So last week I was there. And whether the labor codes are good, bad, ugly, whether it is going to serve the masses, see, the real answer to this is it depends on who you are. For example, I am a communist. For example, this is just an example. I am a communist, for example. Karl Marx said, God made the mountains, God made the trees, God made the fruits. Who are you to derive profit from it as a human? When God has created everything, who are you to make a profit out of it? Profit, according to Karl Marx, is a dirty word itself. He said profit is a dirty word. All the means belong to everybody. Who are you to take a profit? So if you are a communist or I am a communist, I will say what nonsense is happening. What are these labor codes? It depends on who I am. Now I shift myself. I am a capitalist now. I said, yes, you also be rich. I will also be rich. India is having land. India is not having money. So we invite a few multinationals. The Germans are having money. So the Germans come in India. Germans put up a factory. Sons of the soil, that is Indians, get a job also. Indians get paid money also. A little bit of a share they take because he's invested the money. And India also gets a share out of it. This is also one business model. This would be a capitalist model. If you are a communist, answers are different. If you are a socialist, socialists are again something different. Nehru also said we are even having our own brand of socialism. So it all depends who you are. And that's why right at the beginning of my lecture, I asked one question, and wherein, with your permission, I said, is there any person or is there any country which does not want to be rich? That today our per capita is so, and tomorrow I want to be poor, and again I want to be poor, and my target is to go below the poverty line. Is there any country or any person? No, we all want to be rich. Moreover, what is the funniest part of India is there is a book written by Honorable Justice Chandrasekhar Dharmadhikari. The book is in Marathi. If you have your hand on it, try to read it. The name of the book is Manusnama, which is in Marathi, in which Chandrasekhar Dharmadhikari sir gives an example. And while I was reading the book, my eyes got stuck on that example. He said there are so many workers, labor in India. And that labor has got a son. He goes to a college and he is also striving hard and this and that and everything and is working very hard. And what is the dream of that laborer? That my son will study hard and tomorrow he will also build a factory and he will also earn money. So work-wise, the laborer is having a dignity of labor, but psyche-wise, that is mentally, he is already a capitalist. He does not want his son to be a laborer and work like him. He wants his son to travel in a Mercedes car, that he will be rich. Maybe I am not rich, so what? But my son will be rich. So work-wise, he is into the dignity of labor. Yeah, dignity of labor is there. No work is small and big. Even Mahatma Gandhi said so. But by psyche-wise or mentally, he is already a capitalist. So all these things matter very much. Now you see, I spoke on one thing which is called as outsiders into trade union, and I told you Mahatma Gandhi was the first outsider. Then we had Sripad Amrut Dange and N.M. Joshi and Manvendra Nath Roy. Who is Bal Thackeray? Is he a worker somewhere? But he was the president of Bharatiya Kamgar Sena. Who is Sharad Pawar? Rashtravari Congress. He is the president. Is he a worker somewhere? No. This is the concept of outsiders into trade union. And this is all over India. Who is Datta Samant? He is a medical doctor. And then he comes in Rashtriya Mill Mazdoor Sangh, all the mills in Bombay and all of them, everything should be closed. And then there is a strike. And then there is a dadagiri. And then people who want to work also are not to work. Have you ever thought, people have done PhDs. How did, I mean, just allow me, how did this concept of bar dancing come in Bombay or in Panvel? Who are bar dancers? Bar dancing, earlier it was not there, a little bit here and there. What is bar dancing? Ultimately, it is sophisticated prostitution. How did this come itself? These daughters of these mill mazdoors, when they came of age, father does not have a job, staying in a chawl, they have to make 2 square meals to have 2 square meals, took up to bar dancing. Bar dancing is a product of the Bombay Mill strike. See, the byproducts are too huge. It affects your sociology also, right? When at that point of time, R.R. Patil was the home minister, he said, we are going to not allow all these things in state of Maharashtra. We are going to ban all these bar dancing things. Matters traveled up to the Supreme Court that bar dancing is my profession. It is under Article 19(1)(g) in Part 3 of the Constitution. So your first question, are we late? Answer is yes. Your second question was that, if I have really understood you, that industrial something you said, but this will depend on
No,
who you.
some those criticizing these changes are saying these are not the labor reforms, they are industrial reforms.
Those criticizing, who are criticizing? Now you see, see, in India, we are having a fashion. What's in fashion is you either belong to the union or you belong to the management. You never belong to the industry. Point is, we have to belong to India. Whether union wins or our management wins is not the point. It's national. I'll give you an example. I was representing a 5-star hotel in Pune. And one steward, that is a waiter, he started eating a soup. What is the cost of a soup? 250 rupees. And then they objected, no, you should not eat it because, I mean, this is for the guests, whoever are staying in the hotel. It's 250 rupees. And then they said, Saab, kya hota hai? Ek soup peene se kya hota hai? Then everybody should go and have that soup. It is made for guests, not for whoever is working there. This sparked off. That led to a strike. Let me tell you, the first room was sold at 12,000 rupees per day. And the last room was 8,000 rupees per day. Total hotel was closed for 62 days. Everything. Sales tax, income tax, this, that, everything is closed. Ultimately, Hussain Dalwai, who was the then labor minister, had to intervene. And I was representing the hotel at that point of time. So many marathon meetings we had. question is whether the workers won or the management won. Ultimately, it flared to such an extent, and as you will understand, egos and egos are built. The owner of the hotel was a very rich man. He had 22 five-star hotels all over the globe. And one day there was a call from Dubai. He said, nothing doing, close the hotel. For what? 250 rupees. Who won? Whether the union or the management is not the point. I will tell you who is the loser. The loser is you and me. Because we both want a good dam, we both want good roads, we both want a bullet train, we both want metros. Where is the money? So sales tax we lost, income tax we lost, everything, GST we lost. It is our money. This is what is getting cured. So we are late in implementing the labor codes. Yes, that was a very beautiful question. And the second is, I mean, who is opposing? Who is opposing? Workers, you say earlier, did you get gratuity for 1 year? Answer is no. Right from 1972 till today. Today you will be getting gratuity. Fixed term employment, you will be getting that also. So in my view, I mean, in a democratic country and a society, you can criticize anybody's view. But in my view, this is a balanced approach. I will not say it is lopsided. I will not say it is purely for the employer or it is only for the employees. No, it is for both. The only thing is, that's what an example I gave you, that if I am riding a bicycle and there's nobody at the signal for 10 years and suddenly a Havaldar appears, it's an irritance to me. What is this? Till yesterday, nobody was here. Now somebody is stopping me. So with any change, there is going to be a bit of a resistance. Question is, simple question. Do you want to be a $5 trillion and $7 trillion economy? Or would it be, I mean, India has reached the moon also, and Pakistan, we both became independent at the same time. India has reached the moon and Pakistan is trying to reach India through its borders. That is the funniest part of it. They are nowhere. You see Pakistan sites or YouTube videos. They are in full praise of India. Where is Pakistan and where is India? The question is, we have progressed. And I will again repeat, I will not blame Congress or I will not praise BJP. It's not I'm holding the brief which I made it clear. Congress has also laid some foundations. Pandit Nehru has also laid the foundations right from the first 5-year plan. We had Nagarjun Sagar and Damodar Valley Corporation and Bhakra Nangal and Bharat Heavy Electric and Steel Authority of India, the big industries. They are not created yesterday. They are since 100 years. But then it is your India, whether you blame BJP or whether you claim Congress. Taiwan, Singapore, Japan, China, USA, Germany, UK, they are not bothered how you run India. They just want a profit. And the point here is, do you want a share in the profit and do you want to be rich? And that's why I started my lecture with that. This is an assumption that we all want to be rich. And then let's go for something better. And then little bit here and there, yes, there are bound to be, I mean, you can find faults with God also. That's not a point. Yeah, that right also is with you. We all have a right to believe, right to fundamental right of speech and expression and everything we know. You cannot have a faultless proposal. It's like selecting an Indian cricket team. Why should Sachin Tendulkar be there? Why not this one should be there? An Indian cricket team satisfies nobody. This happens with any law. It is not going to satisfy everybody. Some will be disgruntled. That is okay. We will accept his criticism in a positive sense. Let us do that also. But then in my opinion, which in the eyes of few, I may be totally wrong also, but this is what is my humble experience for 3 decades. And the question is that this is a balanced sort of an approach. Let us give it time. I mean, just on paper, even the rules are not there, and we start criticizing from day one is also not a correct posture right now. Okay, so let's give it time. We've given Congress and all of those people 75 years, so let's give them also. Let us see.
Thank you.
Yes,
Thank you.
madam. Yes, thank you, sir.
Thank you.
Is there any question? We'll take a last question because of the time constraint.
Hello.
Yeah.
I'm audible, madam.
Yeah.
Yes, sir. Yes, sir.
Sir, after the codification, labor law codification, Do you think that, sir, economical flexibility given the more priority than labor welfare, sir? Principles of labor welfare.
No, labor welfare is not bartered or bargained. There is labor welfare also, and flexibility is more because you see, let me tell you, in United States of America, you want to start a company, you think that I have to start a company at 8 o'clock in the morning. Then with a few telephone calls and a few portals, by evening your company is already launched. This is ease of doing business. That is all. By evening you already have your company. Government says do business now, earn money, add to the national wealth. In India, can there be a formation of a company in one day? You go this thing, that thing. Forget that. When I was a student of, students, friends who are, I was in your class. I remember I was in University of Pune, and there are 4 challans I used to be filled. We have to fill 4 challans. And then sometimes I cursed one of my friends. His name was Ram. So 3 letters, RAM, finished. Mine was Srikant, Balakrishna, Malegaonkar, Sobhini, 4. I'm just writing and writing and writing. Yeah, see everything with your computerization. Even today, this paperwork, even your CPC is an impediment for this. I talked of code pressurization, and so many of the cases are in cold storage. The basic impediment for this is the CPC itself. For example, what is your name? It's written there. What is your age? That is also written. What is your case? That is also written. So again, you have to make an affidavit. Why? And if you see in civil courts, you have a pure application of CPC, whereas in family courts, you see labor industrial courts, you see there are judgments. Technical rules are not applicable, though CPC applies, but the technicalities do not apply, is what they say. So why can't we remove all the technicalities everywhere? So this is an attempt. And moreover, I am not saying this could be a foolproof plan. There could be mistakes also. But then you see, 1947, we had the Crude Industrial Disputes Act, and then there was an addition of so many judgments. Safdarjung hospitals and Bangalore Waterworks and this and that, and so many cases were there. Likewise, it would happen here also. Let's wait. Yeah. Yes, sir.
Thank you very much, sir. Sir, if there are any further questions, I would like to forward it to you.
Sure.
Yeah, because as you previously told, you had the pre-engagement, some commitments are there due to the time. That's why I'm stopping here, sir, with all your due permission. And now I would like to really place on record my sincere gratitude on behalf of the college, on behalf of the students and the faculty for bringing us a very bird's eye view of the whole 4 codes. So it's a vast subject to be covered, but within the stipulated time, you have really given us a very brief understanding of the very important provisions and very systematically and organized way. It was really a very good insight into not only the theoretical changes but also the practical implications it would have on the labor welfare areas. And your expertise, your opinion have also given us a very good view of the present transformation of the labor welfare legislations. So you are enlightening. Thank you once again, sir, for your enlightening session, which is truly inspiring and also motivated us to study more about these changes and to accept it, as you said, that let us give us time and be optimistic regarding the changes, which have been which the objective is to bring very positive changes also, and to shut off all the drawbacks which we had earlier. So towards this good, very refreshing, very motivating and enlightening speech, once again, I thank you with all my gratitude, sir. And I also invite you, if further there are such deliberations, because in one time we won't cover it. So in further also, we'll be really happy to see you and welcome you to our college, sir. Thank you. Thank you for your very valuable time out of a very tight schedule. I can understand you are handling so much of work, sir. So thank you very much. It's only your dedication, it's only your interest and passion to meet the students and to bring awareness on this topic. Thank you very much once again. Thank you. I also thank you, sir. I also thank our principal, Dr. Poonam Nathani, madam, for arranging and for for suggesting this particular topic for conducting as a webinar. I also thank our in charge principal, Dr. S.A. Mahajan madam, for organizing, helping out, and all the faculty members also who made it possible to conduct it in the seminar hall. I also thank for the patient listening to all my dear students who were very keen in understanding this topic and also participated well. Thank you very much. Thank you one and all. I wish you all the good day, sir. Thank you once again.
Thank you.
Thank you.